You submitted a request to your HOA. A fence color, a satellite dish, a parking exception. The board said no. No explanation, no conversation, just a denial letter and a sense that the decision is final. In California, it isn't. There's a process built into state law that most homeowners have never heard of. And once you invoke it, your HOA doesn't get to just say no and walk away. They have to sit down with you. Today, we're going to show you exactly how that works. If you've ever been denied, fined, or ignored by your HOA board, this is the video that shows you the one step almost nobody takes first. Subscribe to Community Living for practical HOA education. No drama. California law calls it Internal Dispute Resolution, or IDR. It's built into the Davis-Stirling Act, the law that governs most California HOAs. It's not a lawsuit. It's not arbitration. It's a required internal process for resolving a dispute directly with your association, without a courtroom and without a lawyer. Every California HOA is required to have a process for this. And here's the part almost nobody knows. IDR applies anytime you have a dispute with your association over your rights, duties, or obligations, under state law or under your own governing documents. In practice, that covers a lot of ground: a denied architectural request, a rule violation you disagree with, a records request the HOA ignored, even a dispute over how an election was run. If the disagreement is about what the association can or can't require of you, there's a good chance IDR applies. Here's the requirement that makes this worth knowing. Under California Civil Code Section 5910, if a member invokes this process, the association is required to participate. Not may, not at their discretion, required. That means the board can deny your original request. But once you formally invoke IDR, they can't simply ignore you. They have to engage. Requesting IDR is simpler than most owners assume. Put it in writing, an email or letter to your board or management company. State clearly that you're invoking your right to internal dispute resolution under California Civil Code Section 5905, describe the dispute, and request a meeting. Keep a copy of what you send and note the date. That written record matters if the dispute continues. The law requires the process be fair, reasonable, and expeditious, but it doesn't dictate a rigid format. Most associations handle it as a meet and confer session, you and a representative of the board discussing the dispute directly. You don't need a lawyer to participate. You're not proving a legal case. You're explaining your side directly to the people who made the decision. This isn't a courtroom, and it doesn't guarantee an outcome. The board can still disagree with you after the meeting, and it's not the only dispute process California law provides. There's a separate, more formal step for disputes that go further. We'll cover that one in a future video. What IDR does guarantee is a conversation your HOA is legally required to have with you if you ask for it. Before you assume the decision is final, take these steps. 1. Confirm your dispute involves a right, duty, or obligation under state law or your governing documents. That's what makes it IDR eligible. 2. Put your request in writing, citing California Civil Code Section 5905, and state the dispute clearly. 3. Request a specific meeting and keep a copy of everything you send. 4. Show up ready to explain your side. Not to win an argument, but to make sure the board actually hears it. Those 4 steps cost nothing, and your association is required to respond. Your HOA board makes a lot of decisions. But under California law, no isn't always the end of the conversation. It's the start of one you're entitled to have. Subscribe to Community Living for practical HOA education. No drama, just the process most homeowners never knew they had. Thanks for watching. We'll see you in the next one.